Good morning. Supreme Court decides on the constitutional validity of Section 17.5C and 17.5D of the CGST Act. These provisions deal with the blocking of credits in certain cases. What were the three questions which were framed by the Supreme Court, and what is the verdict, and how it impacts the taxpayers? Let us try to understand in light of this pronouncement which just happened a couple of minutes back. Supreme Court had framed three important questions. First, whether the definition of plant and machinery, which is used in Section 17.5D, is treated equally with the definition of plant and machinery, which is used in the explanation. It must be noted that Section 17.5D uses the word plant or machinery, whereas the explanation to Section 17.5 uses the word plant and machinery. So the first question before the Supreme Court was whether plant or machinery used in Section 17.5D is identical or equal in terms of the phrase plant and machinery used in the explanation. And this has huge implications. Second question is that if the meanings are different, the second question which was framed by Supreme Court is that what is in that case definition of plant? And the definition of plant assumes importance from the perspective that if you qualify as plant, then substantial credit with respect to the goods or services or both received by a taxable person for construction of an immovable property may be eligible in lot of cases, and hence that aspect was very important. The third is the aspect with respect to the constitutional validity of the provisions of section 17.5c and 17.5d. Before we address onto the constitutional validity aspect, let us try to understand what these provisions section 17.5c and 17.5d are. Let's start with section 17.5c. These are the specifically blocked credits, and 17.5c reads as works contract services when supplied for construction of an immovable property. So please note that section 17.5c deals only with works contract services, and it uses the phrase other than plant and machinery. And it also creates an exception except where it is an input service for further supply of works contract services. So as far as the blocking of credit is concerned, the blocking of credit under section 17.5c is with respect to the works contract services when supplied for construction of an immovable property. Now let us understand what section 17.5d says. And when we argued before the Supreme Court, the arguments with respect to 17.5c were slightly different from those arguments with respect to 17.5d for several reasons, and we will analyze the definition of 17.5d to highlight that why we argued in a different fashion with respect to c and d. 17.5d, the blocking of credit is for goods or services or both received by a taxable person for construction of an immovable property other than plant or machinery. Please note that the phrase plant and machinery, which is used in 17.5c, is different because the word which is used as and, plant and machinery in 17.5c, is different from plant or machinery, which is used in 17.5d. Please note that as far as the explanation is concerned, explanation uses the word plant and machinery, not plant or machinery, and hence the relevance of the definition of the word plant will come into play, and that has been very, very categorically held even by the Supreme Court. Now, as coming back again to section 17.5d, goods or services or both received by a taxable person for construction of an immovable property other than plant or machinery. The other phase, which is very important in 17.5D, is on his own account. Now, the restriction comes only when these services are with respect to goods or services received by a taxable person for construction of an immovable property other than plant or machinery. And the last but not the least aspect is on his own account, including when such goods or services or both are used in the course or furtherance of business. So here, what is important and what has been also held by Supreme Court today is that the words plant or machinery is different from the word plant and machinery. So what in nutshell Supreme Court has held today? The Supreme Court has very categorically held that the explanation uses the phrase plant and machinery, and this phrase plant and machinery is different from the phrase plant or machinery, which is used in section 17.5D. And hence, as far as the submissions with respect to 17.5D is concerned, categorically Supreme Court today morning said that the submissions of the taxpayers are accepted. So it's a very, very clear ruling, very, very pragmatic ruling, and we are extremely happy that when we argued on the distinction with respect to 17.5D, the phrase used as plant or machinery and the phrase plant and machinery, that has been accepted by the Supreme Court. The second element which has been decided by Supreme Court is with respect to the constitutional validity. Supreme Court has clearly said that these provisions are constitutionally valid, which does not mean that every transaction which would fall for these disputed aspects would be subject to tax, for a reason, because Supreme Court has laid down the principles with respect to malls, warehouses, etc. And Supreme Court has very categorically said that it will all be factual, which means that the nature of the input services, the nature of the output services will have to be determined. What is the role of the building will have to determine. What is the business, the factual aspect with respect to the business comes into play. Supreme Court has also used very categorically the functional test. So the functional test will come into play. We will have to wait for the detailed order to see what more guidelines have been provided with respect to the functional test. But what is important is construction essential for services. Whether this construction on which the credit is disputed or denied by the tax authorities, is this construction essential for me to render the services? That element has come into play, and we feel that in a lot of these cases, based on facts, based on the essential test, based on the functionality test, the building would be treated as plant, and that will be the relevant key now with respect to the determination of the eligibility of credit. While we expect some litigation to happen, but I think this is a very welcome decision from the perspective of the taxpayers, because the functionality test comes into play, the construction essentiality test comes into play, and the role of the building for rendering that output service comes into play. So, for instance, if it's a mall, if it's renting of the premise, the essential test or the output is the renting, which is taxable service. Now, if I do not construct that building, the functionality test will have to be seen, because without construction of that building, I will not be able to obtain or earn the rent, which is subject to tax on the output side. So, on the holistic reading, the facts will be very relevant. The nature of the business will be very, very relevant. The role of that building, why that construction of the building has happened, what is the ultimate output from that building, what will come, whether taxable or exempt, will have to be seen. And last but not the least, which Supreme Court has also held, is the functionality test becomes very important. So I think overall we are extremely happy the way we argued before the Supreme Court with respect to 17.5D, the distinction between the phrases plant and machinery and plant or machinery has been completely upheld in our favor. And as far as 17.5D is concerned, which will play a major role in determination of the eligibility of the credit, has been decided based on principles. The Supreme Court has very categorically said that as far as 17.5D is concerned, Supreme Court has accepted the submissions of the taxpayers. As far as those two issues which were decided by the Supreme Court were concerned, the matter now goes back to the High Court, because the High Court will now have to decide the eligibility of credits based on these principles. And I repeat, these principles are very important: the factual nature of the transaction, the business of the assessee, the role of the building, the essentiality test for construction of that building, and last but not the least, the functionality test. So I think we are extremely happy. If you like this video, please do like the video and subscribe to our YouTube channel for constant updates on GST and other interesting issues.